Hello everyone, it's the Law Tutor SA aka Mufaro. So today I'm going to be just explaining the differences between application proceedings and action proceedings. So these proceedings are the ways in which a litigant may approach the court, or the way that a litigant may institute court proceedings. So what I mean is, let's say you are an attorney and a client comes to your office and then they consult with you. You do see that they actually have a case, they can sue someone. The first thing that you need to decide is to decide if you're going to start proceedings by way of application or by way of action proceedings. So if you're going to be using application proceedings, then it would mean that you'd use your notice of motion together with your founding affidavit. And then with action proceedings, you start by way of summons. And then also in application proceedings, documents are referred to as process documents, whilst with action proceedings, they are referred to as pleadings and processes. So application proceedings are generally faster and cheaper, so many people opt for it. But then it's not just a matter of just deciding out of the blue. You need to look at the following. How do you know which proceedings to institute? So the first thing that you do is consult your legislation. If you are dealing with a divorce matter, obviously the Divorce Act will be your go-to legislation. If you're dealing with the Maintenance, your Children's Act, or whatever law that you're dealing with, you need to go to your legislation and see what legislation prescribes. And then if the legislation is silent, then you ask yourself, is it compulsory to use summons proceedings? Proceedings like divorce, obviously you need to use your summons. And then the third question that you ask yourself again is, does the matter fall under neither of the above categories? If you still cannot decide, then you would need to ask yourself, is there a real dispute of fact? So if there's a real dispute of fact, that's obviously your summons proceedings, because you will need oral evidence. Remember, with summons, everything remember with your summons, you will go to court. There's a trial stage, you go to court and then you argue, you get oral evidence and all that. But with your application proceedings, everything is done on paper, everything is argued on paper. So if there is a real dispute of fact, that means you're going to need to argue it out. So it's obviously your action proceedings, which are your summons. And then if there is no dispute of fact, you can go ahead and use your application proceedings. And then sometimes you find out that there is a dispute of fact, but it can be solved without any oral evidence. Then you can proceed by way of application. So what do we mean when we say a dispute of fact? So a dispute of fact is not just a denial. It's alleged by one party and denied by the other, and by both with show of reason. So both parties must have reason why they are disputing or why they are agreeing to that fact. So whether it is a dispute of fact, the court may either dismiss the application or order oral evidence to be heard only on those specified issues, or order the parties to trial with appropriate directions as to the pleadings, the definition of issues, etc., etc. That is in accordance with Uniform Rule 65G. That is the Uniform Rules of Court. And then in terms of the Magistrate Court, that will be in terms of Rule 55(1)K, where the court may order oral evidence or order parties to trial.